Hello, everyone. Thanks again for joining us in our continued webinar series on various issues having to do with U.S. immigration law. Today, we're going to talk about the proposed asylum regulations that the federal government issued last week on Thursday, June 11th, that if enacted, will change the body of laws that we currently have and within that space. With me today, I'm again so pleased to have my friend and colleague from New York, Paula Dwyer, who really has over 2 decades of in the field experience within this set of laws, asylum space. He's been doing this for a very long time. I often go to him for tips and advice, and I'm so pleased to have him with us this morning. Good morning, Paul.
I'm delighted to be here. Thank you, Ali. Good morning to you. Or good afternoon.
Okay. Yeah, good afternoon to you. So, Paul, what happened last week?
So on Thursday, the departments, as they now refer to themselves, the Department of Justice and the Department of Homeland Security, jointly released a set of proposed regulations, over 160 pages long, which would drastically redefine and revise both the manner in which asylum applications and related applications are adjudicated, and also the substantive law relating to them. And so that's what's called a notice of proposed rulemaking. And it was formally published in the Federal Register on Monday, June 15, and then people have 30 days within which to submit comments. So 30 days is really a short period of time for such a vast and far-reaching regulation. Typically, you see notices of proposed rulemaking with a 60-day or even longer comment period. So the fact that this is such a short comment period is, I think, evidence that the departments are trying to not give people enough time to prepare and to properly submit comments in response to it. So go ahead.
So, I mean, can they do this? Can the executive branch do this without the advice of Congress?
Well, I think that's interesting, and that we'll talk about a little more as we look at some of the proposed regulations, because some of the proposed regulations really conflict with the statute. Some of them seem to conflict quite literally with the statute, and some of them are inconsistent with the provisions, with the statutory provisions regarding asylum eligibility. So I do think that I think that puts a big question mark over whether or not these regulations can be properly enacted, and if enacted, the extent to which they're going to be subject to judicial immediately, that they will be subject to judicial attack.
And isn't the U.S. obligated under international law regarding, within the asylum law and refugee space?
Well, its obligations under international law really arise under the Torture Convention, as well as the Convention on Refugee Rights. But, the obligations really arise under domestic law, because both of those have been kind of codified, or the U.S. obligations under them have been codified into domestic law. So the U.S. obligations under those arise under domestic rather than international law. And the U.S. has never regarded itself as being subject to the jurisdiction of international tribunals anyway. So even if it is contrary to international law, that's really not going to do anything or help anything, simply because the U.S. is just going to say, well, so what?
Okay, so we have a set of proposed regulations over 160 pages, like you said. Can you talk about some of the top line differences that are in the proposed regulations? Yeah. What's different? What are the main things?
And this is going to be very binary. I'm going to keep dividing things into two. So the regulations propose changes which are both procedural and substantive, right? And then these changes affect both the credible fear and reasonable fear screening process, which is for people who are in expedited removal or subject to reinstatement of removal orders. And then also to asylum adjudications, whether that's before USCIS or before the immigration court. And so the changes so very, very briefly by way of background, so people who are placed in expedited removal proceedings, which is people who are typically people who are detained at the border, are subject to being expeditedly removed from the US unless they express a credible fear of persecution or torture if returned to their home countries. And likewise, people who have re-entered the country and illegally after having been deported are subject to reinstatement of removal, and they have a right to assert a claim of fear of persecution or torture also if returned to their countries. And so those are the two contexts in which those kind of pre-asylum screenings occur. And the regulations propose changes to that. With regard to asylum screenings, they propose, so what happens now is that if the asylum office finds that the person has a reasonable fear of persecution, or if a immigration judge finds that after review, then the person is placed in removal proceedings, and then they pursue their asylum claim there. The regulations propose instituting a separate type of proceeding, not a typical removal proceeding, but a separate type of removal proceeding in which the person is only eligible for asylum or withholding of removal. And so the big change there, of course, or where, as you mentioned earlier, can the executive do this? So the Immigration and Nationality Act in Section 240 says that proceedings before an immigration judge conducted under Section 240 of the Immigration and Nationality Act are the exclusive mechanism or the exclusive proceedings by which whether or not a person should be ordered removed from the US or not. Those are the exclusive proceedings. So the executive cannot turn around and say, oh yeah, but we're going to come up with another one on top of that, right? When Congress has said this is the exclusive procedure for determining whether or not somebody can be admitted or deported, then I think the executive is stuck with that, and they cannot come up with another type of proceeding that people are limited to. And in 240 proceedings, the person can apply for any relief available. As a practical matter, I am not sure that it limits people's ability to apply for certain types of relief, because normally if somebody is placed into expedited removal at the border and they are found to have a credible fear of persecution and they're referred to immigration court, there's usually not much other relief that they can apply for anyway, right? So the types of relief that typically you can apply for in removal proceedings is either asylum or cancellation of removal, which requires the person to have been present in the US for 10 years, which would not be the case if you've been in expedited removal proceedings at the border, or adjustment of status. Again, people in expedited removal proceedings are not usually eligible for adjustment of status. The one exception to that, I think, is perhaps juveniles with special immigrant juvenile status petitions, who may be eligible for guardianship proceedings in state court and then to file a special immigrant juvenile petition. But I think the bigger problem is an intent to remove these cases from the regular removal proceedings and put them into some type of kind of low threshold asylum only proceedings in the immigration court. And so I think that is a problem. Then a second change that's made to asylum proceeding, to the credible fear screenings, is that the mandatory bars to asylum, so the Immigration Nationality Act has a list of mandatory bars to asylum. And typically an asylum officer doing a credible fear screening can say, the person seems to be eligible for asylum. It also seems that he or she may be subject to one of the bars, and then the immigration judge should consider whether or not those bars apply. The reason that those bars are considered by an immigration judge rather than an asylum officer doing the screening is simply because those are often very intensive factual determinations, and they don't lend themselves to what is supposed to be an extremely quick and threshold screening procedure in the credible fear process. But the regulations propose giving the asylum officer the authority to deny a claim based on that fact. A third change is that now, after the interview is conducted by the asylum officer, if the asylum officer does the screening and then says, no, I do not believe you have a credible fear of persecution, and you have the right to seek review of this before an immigration judge. Currently, if the person doesn't respond to that question, then they will deem it waived. Currently, if the person does not respond to that question, then they automatically refer the case to an immigration judge for further review. That's simply because most of the people who are in expedited removal proceedings are probably completely overwhelmed by having been in detention for days on end, having gone through a long and complicated hearing before an immigration officer about their credible fear interview, and they may not understand what that means. So to err on the side of safety, unless the person affirmatively says, no, I do not want the case to be reviewed by an immigration judge, I just want to be deported and I want to go home, they will refer the case to a judge. Now, unless the person affirmatively says, I want this case to be sent to an immigration judge for further review, they will not send it to a judge for further review. And so very few of these denied cases will ever make it for review. Then they also, with regard to reasonable fear screenings, which are to determine if a person is eligible for relief under the Torture Convention or for withholding of removal, they're proposing to change the standard to what is generally considered to be a much higher standard, from a significant possibility that the person could ultimately succeed on their case in court to a reasonable possibility that they would be persecuted if returned. And even though the language doesn't sound particularly different, the proposed wording of the proposed regulation makes it clear that the intent is to have them adjudicated under a much higher standard.
So these are huge. These are huge changes. But just to give context to it, so let's say a citizen of Venezuela comes. Somehow, comes to the, let's say, Canadian border.
Right.
Flies to Canada. She's at the Canadian border, and she's asking for asylum. What happens in that situation? Is that still a possibility?
No.
Okay.
But I also think that it would quite likely not be a possibility under current law either, because of the Safe Third Country Agreement.
Okay, so what if that citizen of Venezuela actually had a US visa and lands at LAX? What happens there?
So they land at LAX and then they say, I am seeking asylum from Venezuela. And so the person looks at the passport and says, oh, I don't think you're coming here for a visit. I think you're coming here to stay. Because all your family are here and you have nothing left in Venezuela, so I don't believe you're coming here just as a tourist. And then the person says, you're right, I'm coming here to stay. I don't want to be sent back to Venezuela. I want to seek asylum. And then they're referred to and they're detained, and eventually an asylum officer would come to the detention center and do what is called this credible fear interview. And that's when the higher standards apply. When the possibility so the proposed changes to the asylum process itself increase additional bars to asylum eligibility, which we'll talk about in a minute. And so all of those bars to asylum eligibility would apply to the person in the credible fear screening process.
So if the person from Venezuela traveled through 2 different countries and spent maybe 30 days in one of them before landing at LAX, is that one of the bars you're talking about?
Yes. Yeah. Spending more than 14 days in any country.
Wow.
Yeah. Or if the person had previously been in the US and had accumulated more than a year unlawful time cumulatively in their life, right? So let's say they had come here on a tourist visa and they had overstayed by 3 months and then they left. And then they came back and another time and they overstayed by 2 months and they left. And then they came back again and they overstayed by 2 months and they left. And then if they could accumulate a year unlawful time like that, then they're ineligible for asylum, even if the unlawful time didn't all happen immediately preceding their application for asylum.
So to me, that just sounds just, you know, as a layperson, I would think that this just sounds counter intuitive to the spirit of asylum law, to seek refuge.
Well, I think what's interesting is, so when I was preparing this and I was going through my notes and going through it, I realized how it kind of stands out how they speak so much and so vehemently about none of these people are eligible for asylum. None of these things will qualify for you for asylum. Also, if you do any of these things, you will not be eligible for asylum. If you do any of these other things, you will not be eligible for asylum. If you've been to any of these other places, you will not be eligible for asylum. And there's nothing, the only thing that is, I guess, a positive thing that says under these circumstances you will be eligible for asylum is, of course, a sort of an acknowledgement of the right-wing and evangelical Christian base that the current government speaks to, because it says that anybody who has been subject to a coercive family planning procedure, basically meaning an abortion, is eligible will be deemed to have suffered past persecution and is eligible for asylum. Which is already the law, but nonetheless, when you realize that that's the one thing that they offer. In terms of the asylum, so let's say you get through the credible fear procedure and you have an asylum case before a judge, or you apply for asylum affirmatively and your case is being decided by the asylum officer or by an immigration judge. So it makes two big changes to procedure. First of all, so under the Immigration Nationality Act, it says that an asylum application must be denied if the adjudicator decides that it's frivolous, and also if the application is frivolous, then the person is not eligible for any immigration benefit ever again in their lives, right? As a result of having filed a frivolous asylum application. So the proposed regulation, and under the current law, a frivolous asylum application is one in which a material part of it has been fabricated, right? Or knowingly fabricated. So in other words, if you go to an asylum interview and somebody has helped you prepare the asylum application and they put a lot of information in there that's false, and you don't realize that until the day of your asylum interview, then you haven't knowingly made a frivolous asylum application. The regulations propose to change that drastically and say that a frivolous asylum application is one that was made for an improper purpose, which clearly refers to people who file asylum applications figuring that if the application is denied, they will be referred to immigration court where they can reapply for asylum and also apply for other types of immigration benefits as well, right? So those would be deemed frivolous asylum applications. Also, an asylum application that is deemed to be foreclosed by current applicable law. That would mean that let's say the law does not favor your current asylum application, but you think the law is wrong, right? This would make it, in my mind anyway, a significant risk that you could be found to have filed a frivolous asylum application by advocating for a change in the law as it applies to asylum cases.
And who makes these findings? Who makes the
adjudicator, either the immigration judge or the asylum officer. Currently, only an immigration judge can make a frivolousness finding, but now under the proposed regulations, also an asylum officer could make a frivolousness finding.
That's frightening.
Yes.
That's also frightening.
The new regulations also, which is significant, they allow for a denial of asylum by an immigration judge without a hearing. So they allow the immigration judge, so let's say you go to immigration court your asylum claim is before the judge. The judge says, I've read the papers, or you say to the judge, I'm going to apply for asylum, and the judge says, well, what's the basis for your claim? And you say it, and the judge says, you know what, I don't think that's a viable claim. So I'm not
without any evidence.
Without any evidence or without any hearing. And then it makes a number of very significant substantive changes to the law. And many of these are based on pre-existing court decisions and court cases, but they've never been codified in the regulations simply because asylum law is constantly evolving, and the situations in which people seek asylum and from which people seek asylum are constantly changing. We have new and changing fact patterns all the time. And so there are concepts which in asylum law, such as persecution, particular social group, political opinion, all those things that change and vary over time, and that asylum law constantly evolves to adapt to these changing scenarios. These proposed regulations would define what constitutes a particular social group. More to the point, they provide a list of things that will not constitute a particular social group. And most of those, or many of those, are already precluded by case law, but nonetheless, there are situations in which there can be exceptions to that. And as we both know, asylum claims are incredibly nuanced and incredibly fact-specific. So saying that if you're claiming persecution because you're going to be because of your status as a long-term resident in the US who will face persecution for that reason on account of being deported, that's not a basis for asylum because that's not being a particular social group. Well, that kind of depends on the country that you're going to, right? So if you're being deported to Mexico from the US, then clearly you may not have a claim for asylum as a long-term US resident. On the other hand, if you are being deported to Syria after a long-term residence in the US, or to Yemen after a long-term residence in the US, you may well have a claim based on status as a long-term US resident because you're going to be perceived as having different political opinion and social opinions, etc.
Or be accused of being a spy. I mean, right now there's countless, and really I don't have a count of persons who are citizens of the US, Canada, or any country within the EU, and they're rotting in Iranian prisons because they're being accused of being spies, and they're not.
Yeah. So under these regulations, you would not be able to seek asylum on that basis. It also proposes to redefine what is political opinion, and it does it in a very, very narrow way that really links it to opposition to or persecution by the state or an organ of the state, but then which would make ineligible for asylum somebody who's a member of the government and is being persecuted by an opposition party. Yeah. It also provides a list of things that it says will not constitute persecution. And again, because asylum cases and what constitutes persecution is so context driven and so fact specific that you really cannot have a list of these particular acts will not constitute persecution because they are so dependent on context. It also talks about nexus. So, for asylum claims, you have to show that you were persecuted on account of a protected ground, such as membership in a social group or political opinion. So that on account of is a key part of asylum cases. Again, the regulations with their ongoing negativity and negative approach and exclusionary approach to it are saying none of these things will constitute nexus. But again, what constitutes nexus or the on account of part of a persecution claim really will depend on the circumstances and the facts of each case. And it's really impossible to say this is nexus, this is not nexus in a broad abstract way and say that this is going to apply to all future cases. It also adds a presumption that internal relocation by the applicant, in other words, that they could go and live somewhere else inside the country and be safe there, they add a presumption of that, whereas under the current law, that's not a presumption, and it's up to the government to provide or to allege and prove that the person could relocate safely internally. And then I think the biggest problem, the hugest problem, is it greatly expands the basis for a discretionary denial of asylum. So under the current law, you're ineligible to apply for asylum if you've been convicted of a particularly serious crime, right, such as drug trafficking, and those with a 5-year prison sentence, right? So it's clearly not a simple drug possession, or even a simple drug trafficking thing will not make you ineligible for asylum. And then the case law for like decades has been really clear that you cannot deny that the facts which would justify a discretionary denial of asylum must be severe, like human trafficking, like very serious criminal conduct, stuff like that. Only those things will warrant a discretionary denial. They propose a list of 12 adverse factors which would warrant a discretionary denial. And those comes from if you've ever failed to file an income tax return, if you have more than a year's cumulative unlawful presence in the US, any type of criminal conviction, if you have spent more than 14 days in any one country on the way to the US before you applied for asylum and you didn't, if you have been firmly resettled in another country. So this list, which is vast and which is incredibly broad, and which is, again, to go back to what we had talked about initially, can the executive branch do this? So I think that a lot of these discretionary denials or basis for a discretionary denial, they cannot do because they are inconsistent with the language of the statute.
So a lot of times, I mean, this is, again, horrific. A lot of times under these circumstances, under our present government, sometimes you think that people don't know what they're doing and they do something that is just totally out of the mainstream and, illegal, right? It seems to me when I was reading these regulations, it seems to me, and I want to ask your opinion, that they know exactly what they're doing, and they're very fluent in asylum law. And it looks like they looked at the end game, and if they want to deny claims to asylum, how do we do that? So they worked their way back, and they pretty much blocked every single way possible to reach that asylum grant, and they covered their tracks pretty well.
No, I think that's absolutely true. I think that the purpose of these is it's not to clarify anything, it is to limit eligibility for asylum. And so what they've done is, if you read the proposed regulations or their justification for it, so beside every change, they kind of list court cases that support what is their position. And so, of course, my initial reaction was, well, in that case, why do you need a regulation? If you have court cases saying that, then a regulation should be unnecessary and redundant. But really what they've done is there's like all the judicial circuits in the US, some of which have, conflicting decisions on immigration law between them. So they've combed through all those decisions and Board of Immigration Appeals decision, and they found the most restrictive one, and then they cited that as justification for their denials. And so,
so they know what they're doing. They know exactly what they're doing. So I expect, so let's talk about the comment period, because you mentioned it. We got 30 days and we're several days into those 30 days. Do you think, excuse me, do you think comments make a difference at all?
Yeah, because the agency is obligated to respond to the comments. Not by respond, I mean they don't have to write to the commenter, right, and say, oh, we got your comment, thank you very much. But what they do is they have to read all of the comments, and then they have to explain in the regulation that is eventually published, like how they addressed those comments. either they agree with the commenters and they have decided not to enact that particular regulation, or they disagree with the commenters and for the following reasons, and they are going to go ahead. So the comments can become important because you can challenge the regulation subsequently if the agency has not given an adequate explanation for why it just simply didn't follow, you know, what was the general consensus of the commenters on the regulation. Having said that, the agency is not obliged to give, so they can assign weight, I guess, for lack of a better way of putting it, to types of comments that are submitted. And so if you have one comment which is signed on to by 11,000 people, that will still be treated as one comment, right?
Right.
So, and of course, generally people read this, people will have typically the same kinds of reactions. And so comments may be similar, and a lot of comments may raise similar concerns. But if those comments are submitted individually by people in their own language and in their own words, then those comments carry much more weight than if you have one comment written down that a gazillion people have signed on to. Then that carries, kind of form letters basically, understandably carry much less weight. And so that's why I think commenting is really important.
Okay, and we got, you know, almost like 3 weeks left. So we'll put the web address where people can submit their comments over here. And also I'm assuming that how this develops, the comment period will lead to further litigation on these regulations.
Well, I imagine, yeah. So, I mean, I would assume that it will be, you know, once the comment period ends, and of course the comment period may be extended, it will be typically some months before the regulation in final form would be published. And then if the regulation in final form is the published regulation is anything similar to the proposed regulation, then I would expect that there would be immediate litigation to enjoin it.
Okay, and then so it's going to take several months, as you said, and we're just months away from elections in November. So do you think that these regulations, depending on what happens in November, will ever go into effect? For example, if Biden is elected, what are his options?
I would imagine that they would not go into effect. But, you know, it's really hard to tell the future. And also within the agency now, there are so many people. So I think that we should not underestimate the extent to which there's a sizable opposition to any notion of immigration from people within the departments, the Department of Homeland Security and the Department of Justice. And I think that even if there's a change in government after the November election, I don't think all those people are immediately going to pack their bags and move on to another position. So I think that, I think we will still have an awful lot of work to do, even if we do have a change in government in November.
I mean, Congress hasn't really spoken on asylum law for years and years and years. Yeah. I think there's a responsibility on the part of the Congress to clarify some of these issues and help alleviate some of the mess. And they're being elected too. And I really think at this point where we are with everything that's going on, as U.S. citizens, we need to, it's not enough to simply ask. We need to demand certain things from our Congress, whether it's a Democratic Congress, a Republican Congress. I mean, we have serious issues within just immigration law that needs to be addressed. And for decades, it's just been a football being passed around from party to party, and the community, us being in the community, have suffered.
Right, but I also think that there's I'm not sure I agree that Congress should reform substantively the law relating to asylum eligibility. I think that it is, for the reasons I stated earlier, I think it's important that the law regarding asylum eligibility be drawn out in fairly broad strokes, enough that it can adapt to changing situations and conditions in countries that we have not thought of or anticipated right now. But I do think that there's needed changes to the procedure and to the process. But I also think that even more than that, I think that the asylum, I think everybody would agree that the weight that it currently is placed on the asylum process, on the asylum adjudication process, is so great compared to the demand for it, right? Or compared to its ability to properly function. So I think the agency is understaffed. I think I'm not sure that asylum law as currently written lends itself very well to the situations that we have, particularly with the Northern Triangle countries. And so I think that there are other legislative fixes that Congress can do without tinkering with the asylum process that would relieve a lot of that weight and that pressure. And one of that could be by providing, short-term non-immigrant visas for people who want to come here and work for 2 to 3 years in unskilled positions. And to do that in a way that those types of visas would be easily available, would not be prohibitively expensive. And that's particularly the case where we have, in the last couple of years, we've seen and we've read everywhere about, shortages of farm workers in California, in upstate New York, in Florida, in very agricultural dependent economies where, farms are closing. And these are big, large scale commercial endeavors that are closing, and they're moving to other places where they don't have this problem with lack of labor. So to me, it's counterintuitive to have tens of thousands of people who are seeking to come to the US, who are fleeing not just economic deprivation, but also persecution at the hands of gang members, and both of which are related. And then on the other hand, you have the US, which is suffering from a huge shortage of labor for, like I said, in agriculture and also in other industries. And so I think it's common sense that, okay, well, here we have two competing problems. So how do we fix this? Rather than, belaboring finer points of asylum law to see how we can make all these people eligible for asylum, why not provide short-term visas for people so they can come here and escape their situation for a couple of years?
Yeah, they're called H-2As, Paul.
Yeah.
Right now, the sheer difficulty of just the process of getting those visas have resulted in California farms with no workers, no farm workers, not enough farm workers, fruits, and the harvest season is upon us, right? I used to live in Fresno, so I kind of know when fruits ripen, and they're ripening now all the way at least through September when the grapes ripen, and all of these fruits in California, there's not enough people to pick them. Yeah.
And that's the thing, like, so that even just looking at the H-2 visas, they are seasonal. They're issued for a period of months rather than years. And they're not user-friendly.
They're not user-friendly at all. So we're gonna do a session like this on H-2As later on this month, because that's really a hot topic in California these days, because we don't have enough farm workers.
Right. And lots of fruit.
And we have tons of fruits.
Lots of fruits. California is famous for its fruits.
Yes, we are. So, Paul, so litigation is coming up. So I do want to plug the American Immigration Council. They do fantastic litigation work, impact litigation. So I will, we'll put the website there. If people want to donate money, I mean, it's a really, Jesus work that they do.
Yes.
I also want to say paulodwyerlaw.com is your website. So if anybody wants to know more about asylum law, visit your website and
email me and call me up.
Ping you. And I want to thank you for your time today.
No, thank you. It was great.
Very generous of you to spend all this time with me today.
It was a delight.
Awesome. Awesome.